This screencast lecture introduces our discussion of formal closings. In our graphical map of the course, a formal closing is one of the most common means used to form significant commercial contracts. At a closing, the parties execute a final written agreement, and they ordinarily don't expect to be legally bound until the moment they sign. In our principal case, Ciaramella against Reader's Digest Association, the parties are trying to negotiate the settlement of disability discrimination and ERISA claims. The plaintiff's attorney, Eisenberg, tells counsel for Reader's Digest that we have a deal. But when the plaintiff, Ciaramella, sees the sample reference letter, he's unhappy with it, and he refuses to sign the written settlement agreement. Reader's Digest then sues to enforce the oral agreement allegedly reached with Eisenberg on Ciaramella's behalf. In the trial court, Judge Bryant finds the settlement enforceable, but the Second Circuit reverses. It's worth noting that the plaintiff here was proceeding pro se before Judge Bryant. Ciaramella had dismissed Eisenberg after their dispute over the reference letter, and the judge granted Ciaramella a 30-day recess to allow him time to obtain new counsel. I suspect that Judge Bryant was frustrated that Ciaramella didn't do that during the recess. But notice that the effect of the court's ruling is to postpone enforceability until the parties sign the written settlement agreement at the formal closing. This approach grows out of judicial concern that premature enforcement will hamper contract negotiations. The textbook note about preliminary agreements addresses precisely this issue. As you've read, the Laval test in some cases imposes a duty to bargain in good faith. But parties most often respond to this possibility with a clause like the one reprinted in the textbook. This express disclaimer signals unequivocally that no statements in negotiations will have binding legal effect. This is what most parties want most of the time. It's a good majoritarian default. In fact, I recently negotiated something very similar in a letter of intent for the sale of a community swim club. The institution of a formal closing is the standard device for large commercial deals and for the settlement of litigation. But postponing enforceability until a formal closing leaves parties unprotected during the negotiation process. They may have to make major investments of time and money to evaluate the deal, and either party might have to forego other promising opportunities while waiting to close this transaction. The main risk that parties face is during the time between the agreement in principle and the time of formal closing. A change in circumstances could affect the deal, and that's one reason that lawyers work around the clock when a deal is nearing a closing. Rather than making the preliminary agreement itself binding, parties frequently use so-called breakup fees to protect this reliance. Company A agrees that if it doesn't go through with its proposed merger with Company B, that it will pay the acquirer X million dollars. Parties prefer to negotiate their own specific protection rather than having a court try to determine what commitments they have made. Thanks for listening.